Hello, this is Han, and this is the sixth in my series of videos on the American criminal justice system for lay people. I want to talk a bit here about trials and evidence. A criminal trial, actually all trials, are not about what we know happened. Rather, they're about what you can prove occurred beyond a reasonable doubt. All criminal trials in Colorado and in the United States have a burden of proof of beyond a reasonable doubt. And this burden lies solely with the prosecution. The defendant has no burden whatsoever to prove his or her innocence. The prosecution must prove the guilt unanimously to the jury beyond a reasonable doubt. I say to a jury because most go to jury trial. A defendant could choose a court trial. I'm not sure why they would. Perhaps the defendant is charged with failure to register as a sex offender, and perhaps the defense attorney fears that having to hear that the guy is a sex offender might prejudice the jury too much and would rather just go for the court for a very kind of highly technical trial about complying with the intricacies of a registration system. Maybe there's that, but most of the time it's a jury trial, and how many jurors is a function of what level of case it is. For a district court case, a serious felony case, you're talking about a jury of 12. For a misdemeanor case, you're talking about maybe a jury of 6. In Colorado, there are municipal courts that actually have the ability to jail somebody, and those muni courts will have a jury of 3. But we're talking about jury trial here, so the jurors have to be unanimous. All of them have to agree. If they do not agree on either conviction or acquittal, the case will hang, and the prosecution will now have an additional 90 days before speedy trial runs out to decide whether to try the case again or to make a new plea offer to see if they can get it resolved or to just dismiss the case. I mentioned speedy trial there. Colorado has a statutory speedy trial deadline of 182 days. In the last couple of years, we've moved to 7-day increments so we can just count the weeks, so we don't have to count, take off time for holidays or oddly dated months. So 182 days is the closest to 6 months that is divisible by 7. I think it's actually something like 26 weeks. So speedy trial is a jurisdictional bar to trying the case, but speedy trial dates from the date of the not guilty plea. So as we talked about earlier, there's some time prior to the arraignment where the prosecution and defense might be trying to work out a case. That stuff is not counted as far as speedy trial goes. Nor is counted times when maybe the case is cold. It's a robbery of a liquor store and they got away and had masks on, and it took them a while for the police to find out who it was. An arrest warrant was issued, and it took a while for them to be picked up. So perhaps 6 months had passed prior to these people being arrested. As long as the case was charged before that 6-month period is, any of that delay in getting somebody arrested and brought before the court doesn't count. The clock starts ticking when the defendant pleads not guilty. There's also constitutional speedy trial, but it never comes up now because the statutory speedy trial is less. It's quicker than what is constitutional speedy trial, which nobody actually knows what it is. So we have statutory speedy trial of about 6 months. Now, this can be waived. The defendant can waive his right to a speedy trial and continue the case. For example, if his attorney needs to get a witness and cannot get the witness and the defense asks for a continuance, he has just restarted the speedy trial clock. Right? The parties might ask for more time to work out a deal, and as part of that, the prosecution might require the defense that as a condition of further negotiations to waive the speedy trial clock. The 6 months will start again. So that can be waived, right? But if it actually gets to trial, the prosecution has the sole burden of proof of proving unanimously to the jury beyond reasonable doubt that the defendant did it. And the prosecution will have all the evidence. In Colorado, we have a discovery system that is actually quite favorable to the defense. Every district attorney's office basically has an open file, and unless it's work product, the defense, meaning like the attorney's strategy, the attorney's trial strategy, right? All the police reports, the statements of witnesses, all that, the defense is entitled to get under Colorado Criminal Procedure Rule 16. There are also some constitutional guarantees about this. They are entitled to get exculpatory information, as well as the statements that the defendant made to the police. So the defense also has all that information as well, but it doesn't work the other way. The defendant does not necessarily need to disclose what they have to the police or disclose what they have to the prosecution, except for as specifically provided, and that usually comes in the form of expert reports. If the defendant wants to call an expert, the court may require that the reports of that expert and the CV of that expert go to the district attorney's office. So the DA goes first. The DA will call witnesses. The defense attorney will cross-examine witnesses. And after the DA is done, the DA will rest. At this time, the judge will recess the jury, and outside the presence of the jury, will ask, will solicit from the defense whether they want to make their what we call the halftime motion. This is the motion for judgment of acquittal. What the defense is saying when they make that motion, and even if the defense will make this routinely, regardless of whether or not it's going to be granted, but is saying that looking at the evidence in the light most favorable to the people and drawing all reasonable inferences in favor of the people, that the prosecution has still failed to make their case, right? That no reasonable jury could find beyond a reasonable doubt that the defendant should be convicted. What this usually means is that the prosecution screwed up and failed to elicit any testimony whatsoever of a critical element of the crime. Because witness testimony is a matter of whether the jury believes that. And that is up to the jury. The judge should not be invading the province of the jury to weigh credibility. But let's say, what you have here is you have aggravated robbery. That is taking a thing of value from somebody by force by means of a deadly weapon or something that looks like a deadly weapon. So if the prosecution, right, forgets to get in the gun, or any testimony that the defendant actually like stuck his finger in the pocket to make it look like a gun, or there's nothing there about gun or knife or anything, then the judge will dismiss the count because the prosecutor failed to establish an essential element of the crime, right? So most of the time, the defendant will prevail on this, and it's not and because most of the time the prosecutor hopefully doesn't screw this up. And at least there's something there on the record that the jury could believe that would establish the elements. Thereafter, if the defendant wants to present a case, and they have no obligation to do so, the defendant may present his case. And in that case, the defense attorney calls witnesses, the prosecutor cross-examines the witnesses, and then after they're done, they could make another motion for judgment acquittal, but it's sort of pointless at this point. And then it goes to the prosecution again, if the prosecution has any rebuttal evidence. Rebuttal evidence is evidence that would not be able to come out but for the defendant's case. So it comes in the form of affirmative defenses or other defenses that the defense establishes, like alibi. Alibi is not technically affirmative defense because I'll get into it in another video, but an alibi defense saying, it wasn't me, I wasn't there, I was here instead, right? And so, the prosecutor's not going to do his job for him. The prosecutor's not going to call these alibi witnesses. And so maybe the defendant calls these alibi witnesses, and now there is somebody that the prosecution can use to rebut those alibi witnesses. And that's what the rebuttal case is for. After that, at the end of the defendant's case, before resting, the judge will advise the defendant on his right to either testify or not. The defendant has to decide at this point, does he want to testify or does he want to exercise his right to not testify? If he decides to testify, nobody can stop him. If he chooses to not testify, nobody can force him to do so. But, they're kind of mutually exclusive, right? If he chooses to not testify, the judge will instruct the jurors that they cannot use his decision to not testify as any evidence against him. They are not to consider it in any way. Obviously, if he testifies, he's going to be subject to cross-examination just like anybody else, and they get to evaluate his credibility just like anybody else. After that, the jury's recessed, and or the jury is given instructions that the prosecutor and the defense have worked out ahead of time. The judge is actually one who decides what instructions will be given, but the prosecutor and the defense will be allowed to propose instructions or object to instructions outside the presence of the jury, and then the judge will read those instructions to the jurors, give them the instructions, give them the verdict forms, and send them to the jury room to deliberate. So that is generally how a criminal trial is conducted. Prior to trial, there will be a motions hearing. We talked a bit about this briefly before, and it's at this motions hearing that the defense gets to kind of go on the offensive by trying to get evidence suppressed so that the prosecutor can't use it in trial. The prosecution has certain motions that they might want to use. The most common is a motion called 404B. That's based upon Colorado Rules of Evidence 404B. 404A is the character evidence rule. It says that character evidence is generally not admissible. And 404B says evidence of other crimes, wrongs, or bad acts by an actor may be brought in, notwithstanding the fact that, you know, it shows the bad character of somebody, if it is not being used for bad character. If you're using it for something else, you can use it. For example, if a defendant is being charged with driving under suspension, right? His license has been revoked and he's driving anyway. And the prosecution needs to prove that this person knew that his license was revoked. Perhaps this person had a prior case where he was charged with driving under suspension and got pled down to driving without a license, right? So now he has a criminal conviction for driving without a license. So long as the prosecution is not using this to say he's the kind of guy who would drive without a license, instead they're saying he was previously charged with this and therefore knows that his license was suspended, right? He was subject to court process where he was advised that he was under suspension. So he knew about it, and so he drove anyway this time. That would be 404B as opposed to 404A. So that's all I have to say about trials and how you get to trial today. If you have any questions or comments, please leave them in the area below. Thank you for listening, and in my next video, I'm going to talk about sentencing.